I call Stuart Nash.
Thank you very much, Mr Speaker. It is my pleasure to take a call on this. It is an interesting bill because, as the last member alluded to, a fundamental tenet of property law is boundaries don't change. But of course we're dealing with a very unusual situation in this case. And let me just give you a little bit of an indication to the situation we are dealing with. And I was surprised when I read this in the regulatory impact statement myself, Mr Speaker, but there were just over 124,000 properties that actually moved between 0 and 20 centimetres, but there were 10,000 properties that moved between 20 and 50 centimetres, and over 1,000 properties that moved over 50 centimetres. So we are dealing with a situation here which is only brought on by the sort of thing where you get in an earthquake, and it does have to be dealt with. But I do have some concerns about this. Megan Woods did allude to the fact we're going to support this as a select committee, but let me run through a couple of issues that I think, well, that I hope will be addressed through the select committee process. But first of all, let me say, and we know this, that New Zealanders have a love affair with property. And I'm not just talking about homeowners. I'm talking about investors. I'm talking about developers. In fact, I think we're trying to deal with one of these situations in the next bill on the order paper when we put the bright line test in. That is going to be a very interesting debate, Mr Speaker. But back to this one at this point in time. What this bill, in my view, seeks to do is minimise the risk of those who are involved in the business of cadastral surveying, or who may have some sort of liability, whether that be the surveyors, whether that be the council, whether that be the Crown. And in a way, that's most important, because there would be nothing worse than a whole lot of cases being tied up in the courts for years and years and years as this sort of thing drew on due to a whole lack of certainty. But there are a couple of things in the regulatory impact statement that sort of caught my eye. And, I don't expect answers now, obviously, but hopefully these answers will come through in the Select Committee. And we've got to remember, Mr Speaker, that this has been going on now for 4 years. The earthquakes, as we know, were in 2010-11. It's now nearly the end of 2015. This is a fundamental issue with regard to property, i.e. where is my boundary, where can I build the fence, where can I situate my property, because nearly everything to do with building a house or a fence has some reference back to where the boundaries are, where you can situate a house, etc., etc. We all know this. But what it did say, Mr Speaker, is that some surveys have been undertaken and approved using a cadastral survey method inconsistent with the preferred approach. And I'm not too sure why this was done, keeping in mind that only licensed cadastral surveyors can actually undertake a survey. So these are men and women who have gone through, I think it's it might even be a 4-year university degree. They are well versed in how this works. And I would have thought, Mr Speaker, that one of the first things that was dealt with Sierra or the Crown or Mr Brownlee was, okay, when we are looking at property boundaries that we know have moved, this is the method that must be used, or if not the Crown, then certainly the Surveyor General, because this was always going to be an issue in Christchurch. And the fact that it has taken so long to come here, and the fact that some surveyors did use a method inconsistent with the preferred approach, makes me wonder why this was done in the first place. Or if surveys were lodged with the Council or the Surveyor General with LINZ, why weren't these particular surveys pulled up and just said, hey, Mr Surveyor, we have slight concerns about your methodology. Can you walk me through why you are doing this? And so we wouldn't end up with the situation we're in at the moment. The other thing that concerns me a little bit is in the regulatory impact statement, it actually says, and I'm going to quote this, it says, because it talks about the status quo. Under the status quo, case law will eventually emerge, this is a quote, to establish the most appropriate approach to surveying within these areas. It is unclear whether the case law will produce a legal interpretation that best meets the government's objectives for the survey and land title system in Greater Christchurch and post-earthquake rebuild, end quote. Now, the thing that concerns me a little bit about that, Mr Speaker, is it talks about the government's objectives for the survey. It doesn't mention there at all the landholder's objectives or the landholder outcomes. And so whenever there is a piece of legislation like this that indemnifies a profession or the Crown, inevitably there are winners and there are losers. Because if there wasn't a winner or a loser, then we would let case law deal with this. But as mentioned, possibly due to the scale, and as I mentioned, there are over 1,000 houses that have moved by 50 centimetres or more, And again, I don't know how many of those are in dispute, and one of my Christchurch MPs may know this, but there are obviously a number of houses or a number of property boundaries that are in dispute, there may be 300, more than the courts can reasonably handle, and therefore what we need to do to just expedite this is come up with a legislative solution where ideally a case law solution would have been the preferred method. But with 300 or 400 houses, as mentioned, we can't work through this. But what we really need to understand with this, Mr. Speaker, is who are the winners and who are the losers. Because we cannot have a situation, in my opinion, where the government is the only winner here, and that is the government's objective to expedite these at the expense of a fair deal for Christchurch landholders. And we must get this right, because whatever the outcome, I think it will there will be aggrieved parties. Now, whether that is the surveying profession who are indemnified, whether it is the Crown or whether it is landowners, what government, what Parliament needs to be able to do is say we went through a very robust process, we understood the arguments, and due to fairness overall, we came up with a solution that meets the requirements of all parties. And that is my concern when I read this regulatory impact statement. It does go on to say, and I understand the arguments about this, until we get a piece of legislation, and obviously there isn't case law, because if there was, that would be, that would set the precedent, that there is a level of uncertainty and cost for landowners. And goodness me, those Christchurch landowners that are still in boundary dispute, how long has this been going on? It has been going on for far too long, and they need a level of certainty. They need the ability to be able to move on, to build that house or locate that fence, which is without having the fear or uncertainty of having to rip it up again. There's no doubt about that. What we also need, Mr. Chair, is surveyors to be able to apply judgments that lead to rules and outcomes that are understood. Because as mentioned at this point in time, my understanding is one of the main reasons for this is because there are inconsistent or conflicting boundary determinations. And there's nothing worse, Mr. Speaker, when you get one surveyor saying this, another surveyor saying this, and where does that end up? If you're lucky in mediation and it's sorted, if you're unlucky yet again, it ends up in the courts, which is far from ideal, especially for residents who will have to foot the bill themselves and no doubt have faced immense cost just in the rebuild process, let alone in taking a case to court where, like I said, there are winners and losers. The other thing also is that there's the belief that there is a lack of clarity about whether the information provided by LINZ is actually an accurate representation of the title. And this is most important, Mr. Speaker, because the LINZ information is what lawyers, is what surveyors, is what real estate agents, and of course those who buy and sell houses rely on. And if we cannot rely on the LINZ information, the cadastral maps that we see on the website when we go on or when we go to a legal office, then the whole system begins to fall down. And again, the last thing we need in Christchurch, and as I mentioned, there are over 130,000 houses that have had some movement. The last thing we need in Christchurch, Mr. Speaker, is legal uncertainty where people, more legal uncertainty, where people are reluctant to buy a house or people cannot sell a property or investors are unwilling to build the necessary rental properties or developers are unwilling to put up a high-rise or basically anything that hinders the rebuild of this city. The risk of that must be mitigated. But as I mentioned, Mr. Speaker, we are going to support this to Select Committee. Unfortunately, I don't sit on the Select Committee, but I'll be watching this with very, very closely because I think there are some precedents that are going to come out of this as well. But as mentioned, there are some questions here. We do need to know who the winners are and who the losers are going to be, but we do need, most of all, we do need certainty. So I have no doubt there are going to be a lot of submitters of this. There will be great interest from a number of Christchurch landowners and the Crown, but we will support this to Select Committee, and so let's see what comes out of that. Thank you very much.
I call Mac Ducey.
Thank you very much.